Welcome to or welcome back to my channel. If you remember in my previous video, I was talking about the grounds of appeal and the skeleton argument in the Depp, NGN and Wotton case in the United Kingdom, and dissecting the grounds of appeal and the skeleton argument. I previously went through the nature of that appeal, which essentially set out that the judgment was plainly wrong in its argument. And I got as far as looking at the nature of that appeal, and this is the second video looking a little bit more at those grounds before in the subsequent video going into the skeleton argument and each of the arguments made in that case. And for those that haven't found it yet, the petition to upturn the judgment in the United Kingdom, which is a very tall bar, but the petition to show how many people would like this to go ahead is linked in the description below. It's linked in the description of each of these videos that I do on this topic. And so without further ado, let's move to the grounds of appeal document once more. So this is what it looks like. So for those that are not familiar with UK court documents, we always have a header such as this setting out the parties and the nature of the document here. And so we looked at the nature of the appeal in the previous video. As I said previously, very rare to say that a judgment is plainly wrong, but this is the broad scope of the nature of these grounds of appeal. Moving to the grounds themselves, because we finished off by saying that this was the paradigm example where there were compelling grounds for the judgment to be reviewed. And so moving to those grounds of appeal in themselves, it set out essentially several reasons, numbered here you can see up to 7, which we'll go through in this video, as to why the judgment, it argues, was plainly wrong. So here you can see it argues that the judgment is plainly wrong and or the trial judge failed to examine the evidence and the arguments with the care that the parties were entitled to expect, and which a proper resolution of the issues demanded for the following reasons, any one of which would be sufficient to justify setting aside the decision in favour of the respondents, but which taken cumulatively render the judgment manifestly unsafe. So in other words, the judgment was in favour of the respondents now of course being News Group newspapers and Dan Wotton, and so setting aside essentially means that it is no longer a valid judgment, and being set aside, there's either a retrial or the judgment just no longer prevails, which is, as I suggest, what should happen. Although the Court of Appeal refused permission to appeal, but that's another story. We can look at that in another video. And of course, much of the evidence which was uncovered later did not feature in this argument. So let's just have another further look. So in these grounds of appeal, the reasoning behind this argument here that the judgment was plainly wrong and the judge failed to examine the evidence and the arguments with care so entitled. The first reason thereof, the trial judge's findings on fact on issues of central importance amounted to bare assertions rather than reasoned decisions, following upon a careful weighing up and reasoned analysis of the evidence given by both sides. Now, this is critical because when a judge comes to findings which are of central importance, in other words, that the main issues in the case and the main things that are supposed to be decided in the case, if there are bare assertions made rather than reasoned decisions, then it cannot stand up to the type of scrutiny that it ought to in such a judgment. A bare assertion, if you remember in my previous video, I gave the example of someone turning up at your door head to toe wet and their clothing wet. You cannot make the bare assertion that they've been pushed in a lake unless you have evidence to suggest that they've been pushed in a lake. So again, a bare assertion by itself is unsafe. And so moving on, as a result, there's no proper explanation for how the trial judge reached these serious findings in the face of conflicting account of events. He failed to give reasons to explain what evidence he found to be sufficiently cogent so as to satisfy the required standard of proof in light of the criminal nature of the allegations complained of. Now again, this is important because Two things, really. First of all, whilst this was a civil trial and the balance of proof, the standard of proof rather, was on the balance of probabilities, which means more likely than not. But even then, the more serious the allegation, the higher that standard of proof should be, even though and notwithstanding it's a civil case. And in any event, in this particular case, the judge did make reference to the criminal standard of proof. And so in doing so, because the nature of the allegations complained of within this trial are of a criminal nature, a relatively serious criminal nature, then the standard of proof should automatically be that much higher. So there needs to be a much higher standard of proof in this case to found fact on these allegations. So that is what that part is saying there. So failed to give reasons to explain what evidence he found to be sufficiently cogent as to satisfy the standard of proof in light of the nature of the allegations. Secondly, the judge failed to test the oral evidence given by Miss Heard against contemporaneous document evidence or the evidence from numerous independent or professional witnesses. So by testing the oral evidence given by her and other contemporaneous documentary evidence, this is exactly the point for reaching a finding. The evidence needs to be tested, and it's not simply a case of produce the evidence if another party disagrees with it. Further, he reached conclusions on this evidence which were outside the bounds of reasonable finding, particularly given the implausibility of many aspects of her account, which, if treated or followed through consistently, would have critically undermined the veracity of her account of the physical assault she claimed to have been subjected to, or the physical injuries she allegedly suffered, none of which were supported by medical evidence. And so again, without the benefit of proper medical evidence, and I've said many times before, I mean, I injured my knees sort of 6 weeks ago. I've probably got 100 photographs of it now because there's obviously an ongoing case which I can't really talk about, but I have probably 100 photographs of the injury in its developmental stages and all that sort of stuff. So if someone does have these kind of injuries, you would be seeking medical evidence. There would be lots of medical evidence. There'd be lots of photographs, not just one or two. And if her account of the alleged physical assaults were real, there would be significantly more evidence to support the judge's findings in that regard. And so this is what essentially this paragraph is saying. Moving on to paragraph 3, the trial judge failed to examine or assess properly the credibility of Miss Heard or the other principal witnesses on behalf of the respondents, including by ignoring contradictory or relevant evidence relied upon by the appellant that undermined such credibility or the account which was given. And now I've talked a lot about the credibility issues in this case. There were several credibility in this case. One of which is coming to light with the Australia perjury charges, which, by the way, I will feature on Popcorn Planet later today. So make sure you head over to his channel to catch that one. I feature with him later today, talking about the Australia perjury charges. So the issue of credibility is a serious one. In any case where a witness, whether it be the complainant or a third-party witness or whoever, where their credibility is seriously damaged, it should feature and it should have a significant impact on the weight of their evidence and the credibility of their evidence and so on. So this is essentially what this paragraph is talking about here. Judge failed to examine or assess properly the credibility of Ms. Heard. That's a very polite way of saying she shouldn't have been taken as a credible witness because of all of the allegations against her. She pleaded guilty to the perjury charge, albeit on a much lesser count than is now being investigated by Australia. It seems that having uncritically accepted at the outset Miss Heard must have been correct in her allegations, the trial judge discounted evidence to the contrary, even attributing to her evidence which she did not give in order to cater for the obvious weakness or improbabilities in her evidence. And I've mentioned this before. There were bits of commentary, if you will, that were inserted when discussing her evidence, such as the judge had said she hadn't yet decided to go public with her allegations. Therefore, one of the reasons to wear makeup would have been to cover up the bruises. But that wasn't part of her evidence. So it essentially enhanced her evidence. The judgment, this is, essentially enhanced her evidence to come to the findings that it did, which is wrong. It shouldn't be doing that. Paragraph 4, the trial judge failed to consider or otherwise address in his mind the impact of finding that one of the assaults alleged by Ms. Heard in the confidential judgment did not happen. So by something not happening, then it should affect and impact the finding throughout the judgment. So this is a standalone point. So if someone has made something up, it should affect, or it should certainly be addressed and be borne in mind throughout the remainder of the judgment. If someone has made one thing up, perhaps they've made up the rest. Paragraph 5, given the seriousness of the allegations involved and the fundamental importance of assessing the credibility of the starkly opposed accounts given by the appellant and his numerous witnesses, several of whom were independent of him, on the one hand, and Miss Heard and her close friends on the other hand, it was incumbent on the trial judge to closely examine and provide a proper assessment of the principal grounds on which Miss Heard's credibility was challenged, or at least address them, and he did neither. And again, this is a significant point, because when assessing credibility with, as it's put here, starkly opposed accounts given by the appellant, of course, Johnny Depp, and numerous witnesses, starkly different from that of Miss Heard's evidence and her close friends, it was incumbent, so in other words, he should have closely examined and provided proper assessment on the principal grounds that her credibility was challenged. Again, coming back to the credibility, because it's a serious issue. Conversely, the judge made no findings that the appellant or other witnesses were dishonest, as would be inevitable given his findings of fact. Now, this is also a significant point, because if a judge has come to a finding that is against a party, but that party has given firm and robust evidence to that point, it follows that the judge ought to have found that he was dishonest. But of course, to find that he was dishonest would have required a basis of fact and evidence. So if you can prove that someone has been dishonest, for example, people say that Amber Heard had been quoted in the TV show to say that she had donated it, given it all away, the money, this is. However, that wasn't the case, and it's later shown that it hadn't been given away. Then people might argue that that is dishonest, and there's a basis of fact for it. So here, in this point here, if the trial judge has come to a finding which is so against Johnny Depp, he should have found and had a basis of fact upon which to base that finding that he and his witnesses were all dishonest, but he didn't. And failing to find that they were dishonest and providing reasoning as to why they were dishonest, an evidential basis as to why they were dishonest, then it only stands that their account remains true. But that's absurd, because you cannot have a judge finding that their account remains true whilst making a finding against them. So obviously you would expect, and so this is why I'm explaining this point, you would expect, and it would be inevitable, to find that he and his other witnesses were dishonest and have an evidential basis to base that upon. Despite this obvious and fundamental flaw with the judgment, the trial judge failed to give any real reasons as to why he did not accept their sworn testimony. And I've said this again before. I've said that even in the judge's own judgment, said that a witness giving evidence in court is more likely to be believed because they're giving evidence under oath. They understand it to be important. Their evidence can be tested. Questions can be rephrased if not understood, and so on and so forth. And in doing so, their testimony should be believed, even in the judge's own words. However, without, remember, having made any finding that they were dishonest, didn't accept their testimony, both Johnny Depp and each of his witnesses, some of whom were independent of Johnny Depp. And so, without finding that they were dishonest, didn't give reasons as to why he didn't accept their sworn testimony live in court, which even in the judge's own consideration throughout the judgment is a significant point, because when someone gives evidence in court, they are generally taken to be more truthful, and even the judge accepted this within this judgment, but nonetheless failed to give reasons why he didn't accept their testimony. And finally, a legal point here which warrants a bit of explanation. So I'll read it first. But the trial judge erred in law, in other words, just made a mistake in law, in applying this part, Section 4.1 of the Civil Evidence Act 1995. Now, the Civil Evidence Act 1995 is a UK statute which governs much of the introduction and the admissibility and the use of evidence in civil trials. So, made an error in law when applying Section 4 of the Civil Evidence Act to the evidence of the LA police officer who attended Miss Heard's home. Now, we all remember the evidence from Officers Sines and Haddon. After one of the alleged incidents of domestic violence and whose subsequent deposition in the legal proceedings in the US, the appellant relied upon. The respondents obtained an order. So the respondents, of course, being the newspaper and Dan Wootton, obtained an order pursuant to the civil procedure rules requiring the officer to be cross-examined. Now, this is important because if you want to test evidence and you want to contradict evidence, you must test it properly. So they obtained an order requiring the officer to be cross-examined. So if they wanted to say the officer was wrong, mistaken or otherwise, they needed to cross-examine that officer. So the respondents obtained an order to require the officer to be cross-examined, and the officer attended court via a video link for that purpose. The respondents, and here's the key point, the respondents made a deliberate decision not to cross-examine him. The officer's evidence was thereby unchallenged, and the Civil Evidence Act had no role to play. Further, the evidence of this officer, which despite critically undermining Miss Heard's veracity went unchallenged by the respondents, was discounted by the trial judge, as was the evidence of his colleague, an officer experienced in domestic cases. So, explaining this a little further, when applying this section of the Civil Evidence Act to this bit of evidence, when there was an order to have this officer cross-examined, because they made a deliberate decision not to cross-examine the officer, the evidence was unchallenged and should have been accepted. It should have been maintained as the evidence, and if it's unchallenged, you're deemed to accept it, generally, in UK civil procedure, in England and Wales at least, for those in Scotland. But if evidence goes unchallenged, you're deemed to accept it. And that's generally an international principle. If evidence is unchallenged, you're generally taken to accept it. Not necessarily always and in its entirety, but generally if evidence is given for a specific point and it goes unchallenged, then generally you're taken to accept it. But the officer's evidence was thereby unchallenged, and the Civil Evidence Act had no role to play. So this should not have come into play in this case, because they made a deliberate decision not to cross-examine him. And further, the evidence of the officer, which critically undermined her veracity, went unchallenged by the respondents. So his evidence undermined Amber's evidence and credibility as to the account of that particular incident. But that fact was discounted by the trial judge, as was the evidence of his colleague, Officer Sines, of course, an officer experienced in such cases. So these are the primary grounds. I'm going to go through the reasons that it argues to grant permission in another video, in some more detail, in context of the rest. But those are the principal grounds. So in essence, we have arguments over credibility, we have arguments over unchallenged evidence, we have arguments over failure to find that witnesses have been dishonest, whereby if their evidence is taken to be wrong to such a degree and such allegations, then you would expect that a finding that they've been dishonest. But there was nothing of the sort. There was no finding they were dishonest, let alone a basis of fact to support that finding, and a failure to test Amber's oral evidence, contemporaneous evidence, and so on and so forth. So broadly, this argued that the judgment was plain wrong. Of course, this application was ultimately refused by the Court of Appeal. We'll come to reasons why in another video. I've gone briefly over that in a previous video. I will do that in more detail in a future video. But the Court of Appeal is very slow to grant permission to appeal, which is the principal reason why I've set about this petition to reopen the appeal. And I would urge the court to do it of its own motion. Ordinarily, it's by application. Yes, it's ordinarily by an application, but there is nothing in theory to stop the court doing that of its own motion if it finds that it would be contrary to natural justice. So you'll find the link to that petition in the description. And I hope you enjoyed this overview of what were the grounds of appeal argued. And in the next videos, we'll come to the skeleton argument and break down each of those arguments in detail. Remember, the grounds are just the broad nature and grounds of the appeal, why there's an appeal in the first place. The skeleton argument goes into each of the arguments for what is described in these grounds of appeal. And then I will also, to be fair to the situation, I will look at the counter skeleton argument against this application. And then we'll come to the appeal judgment and so on. So, as I said, breaking these videos down into bite sizes, but I hope you enjoy this breakdown and analysis. I do hope you like the video. Literally hit that like button, because that tells YouTube that you would like to see more of this. Make sure you subscribe and hit the bell, leave a comment, and make sure YouTube spreads this about. So with that in mind, don't forget to catch me on Popcorn Planet with Andy Signor later on today. And enjoy the rest of your day. Thank you for watching.